Hey YouTube family and GN subs, Humberto from GrayLaw TV. Hope you're doing well. And today we have a really important video for you. It is on how to respond to a notice of intent to deny. When you have a marriage case and immigration wants to deny it, what they will do first is they will send you what's called a NOID, notice of intent to deny. We're going to go through all of it today. We're going to give you the law. We're going to let you know how to respond specifically to these actual requests for evidence. Those of you who are new to the channel, again, my name is Humberto Gray, attorney at law here on the West Side, Los Angeles, and I bring good news. I also break down complicated subject matter such as this. You can go to my playlist. You can find specifics on marriage, fraud, cases. We're going to go through some of those today, as I just said. So hey, stay tuned, a lot to unpack. All right, so you can get a notice of intent to deny called a NOID on 3 different type of cases, and you need to understand the difference in the 3 type of cases. One is the I-130, that's the initial marriage petition. Number 2 is the I-751, that's after you have the conditional green card, you have to make an application to remove the condition. That's an I-751. You can do that 2 ways. You can do it jointly, and you can do a waiver. That's in the case that you're getting a divorce, okay? The third, a lot of people don't know this one. It's in connection with an N-400 citizenship interview. A lot of times at the citizenship interview, if they suspect that there was past fraud, but it never came up in the I-751 interview or in the I-130 application, they will try to bring it up in the context of your citizenship interview. They will start asking questions about prior marriages, okay? Really important. And if they do, a lot of times what they'll do is they'll issue a NOID, okay? And they'll try to find fraud, believe me. And they'll deny it and they'll try to send it to court. We've had it time and time again. All right, so it's really important when you're responding to these notice of intent to deny, you have to let USCIS, the Immigration Service, you have to let them know that you know the law, all right? So I'm gonna do a brief recap of the law. So important, folks. You can't just say, oh, the officer treated me unfairly in the interview, blah, blah, blah. You need to have the law. You need to be armed with the law. I'm gonna give you the law. Share it with your lawyers. This is new stuff that came out, and I'm gonna link to previous videos so you can know the law. But we're gonna really briefly go through it here. Really important that you have this stuff when you're responding to the notice of intent to deny. All right, first is the law with respect to the I-130 petition. I have a really good marriage fraud video. I'm putting the link to that video here in the description box below. Go to that video, check out the law on the I-130 marriage fraud. Really important. For purposes of today's video, the law for an I-130 basically is preponderance of the evidence. The evidence that you submit, immigration has to accept that evidence that it is more likely than true that it's bona fide and relates to the marriage, okay? That's an important point. Secondly, recent cases on I-130s, the service has to provide you with derogatory evidence, okay? So again, later in the video, I'm going to tell you exactly how to do that, all right? So stay tuned. Next, the law with respect to I-751 petitions. Different set of rules, different law. I'm going to list these cases in the description box below so you can make use of them, okay? Basically, however, the standard on I-751 petitions, there has to be a basis for a denial of an I-751, okay? There has to be evidence. The service has to provide that evidence. Cohabitation, consummation are not the only factors that they should consider. There are other factors that they must consider. And then this is really important. A finding of fraud has to be based on substantial evidence. There has to be a lot of evidence that the service brings forward to prove their case. Again, this is in the context of responding to these NOIDs, right? You have to let them know that you know that and that perhaps there's not sufficient evidence in this case that you're providing. You say, I know the law, here is the law, okay? This is great. All right. In I-130 interviews and I-751 interviews, really important here. I'm gonna put the law in the link. It's the adjudicator's field manual. It's how they must conduct the interview. This is important stuff, folks. Okay, you can let them know this officer did not follow its own instructions that is mandated by this manual. Okay, let them know, go through it. Go through this manual. It's important stuff. You're going to find some great stuff in there. All right, again, for the citizenship, for the naturalization, you get a NOID. Here's the law. I'm going to put it in the link below. These are the cases that you cite. Basically, it has to comport with fundamental fairness. It has to be fair the way that they do this. They can't, in the context of a citizenship application, talk about a marriage that happened 20 years ago. And trust me, they try to, and it's not even relevant to citizenship. You already have your green card. You already went through that. So look in terms of responding to the NOID, put in, this was not fair, and these are the cases that show you how they must adjudicate the case. All right, so that's the law. Important stuff, folks. Go to the prior videos, check it out. All right, how do you respond to a NOID? 3 things, folks. 3 things that are really important, all right? Number 1, you request supervisorial review. You request that a supervisor look at this case. You have the right to do that. Supervisors seem to be more reasonable. Certainly when you have a really bad NOID, you want to get it out of that officer's hands. You want to make sure that a supervisor is looking at this. Certainly if you're citing this law, the officer's not going to be happy that you probably know more than the officer, but the supervisor will know. Ask for supervisor review. I find that's really important. Secondly, and I can't stress this enough, folks, one way to respond to a notice of intent to deny, provide physical evidence. Can't stress enough, you need to provide joint documents to prove the marriage is valid, okay? Both in the context, well, certainly in the context of the I-130, I-751. All right. The third thing is you request the transcript Q&A. This is so important. So in the I-130 interview, they may separate you, for example, and the officer is taking notes of the question and the answers. So when you come together as spouses, you request to the officer that you want to sign your answers under oath, and then you ask for a copy of the Q&A. Why? Most immigration officers make up answers all the time. I was just in one and I take copious notes. I make sure that my clients sign the Q&A, and then I make sure that they get a copy of it. This officer made up questions and answers. It was really bizarre. Not only did the officer ask leading questions, but the questions weren't the same questions that they asked in the interview. And the officer in the NOID said that, oh, here was the question, here was the answer. Not even close, folks. It was not the question, it was not the answer. Now I have the transcript. I can show in my response to the NOID clearly that this is not consistent. The questions and answers that my client gave and the questions and answers that the officer's making up, not consistent. That's how you win a NOID. Really important stuff. So those are the tips. That's what I use. I outline the law, I get the evidence, submit evidence, look at the Q&A in detail, and I go at it in my response. That's how you do it, folks. Hey, YouTube family, GN subs, thanks so much for watching GrayLaw TV. Click below, like and subscribe, and we'll see you soon.